Hey everyone, Sherry Palmer here for my 4 o'clock. Today it is 4 o'clock Central Standard Time, and yes, I'm in a jacket. It is 23 degrees where we are. I'm pretty warm here in the truck, so I hope all of you are warm and cozy. And today we're going to be talking about why a judge doesn't care about your truth, right? And how you can fix that. So super important this week. Lisa Ling aired her show on CNN. She talked about traumatic issues in family court and the emotions that people go through. So we're gonna keep that thread going here tonight with what happens when you decide that you need to take what's happening to you into court regarding your custody and divorce issues. So I'll give a few more seconds for everyone to jump on and let me know that you're here and you can hear me. Okay, great. Hey Trish, good to see you. Can you guys hear me okay? Because I don't know with the stream at these truck stops whether or not you're getting good reception or not. But if not, just type a message there and I'll try to move a little bit, shift. Not many places I can go. I don't know if you guys can see. I was going to try to flip it around. Let me try to flip it around. I'll show you. It's pretty crowded in here. There's a lot of trucks parked. Okay, see, so like there's lots and lots of trucks here. So anyways, we are in Illinois, where we're broadcasting from. So let's get started. All right. So many of you have already been through this, but if you're still going through it and you're trying to be heard by a judge, then you probably know that when you go into court, let's say you have an attorney that's presenting your case for you, you get there and you want that judge to know everything, right? You want them to know how you were mistreated, how you were lied to, how what they're being told in the motions from the other side are lies. You want them to see you who you are. You want to prove what a great parent you've been. And I hope this doesn't mess up my feet. Okay, hope you're all still there. So you want this judge to just see you who you are. You want them to know what a wonderful parent you've been, because all the other side is doing is saying all the negative things about you. So what happens is you get very, very focused on that mission and you lose sight of what's really important in a courtroom. Okay? And Peter wrote something here. Hey, Peter, all the judge needs is a statute and an allegation. The rest is fact independent. Okay, so we'll talk about that in a minute. Peter's an attorney, by the way, so I love when he jumps on here and gives his feedback or input. It's much appreciated. So back to where we were. So you want them to know everything, and your attorney only has so much time, right? And we're all going to assume you have an attorney until you run out of money. Then when you don't have an attorney, you do it on your own. We'll talk about that before we finish. So your attorney has a limited amount of time. In some districts, they actually time you. Like Collin County is one of them. They may only give 30 minutes each side. And so you've got to be very, very specific about what you're going to present. If there are things that you want to counter before you get into the actual courtroom, you need to do that in writing, and you need to be strategic about it. So people like Peter, attorneys, will tell you, and there goes my light, will tell you that there are things that you don't want to counter, and there are things that you need to counter. And that's really, I'm not a lawyer, guys, but I'm going to tell you what I know just from working with parents, with attorneys in the courtrooms and out, just as a paraprofessional and as a support service. What we find is that you want to be very selective with the things that you are going to put in writing as well as what you're going to present in the court. So in writing, there are some things you don't need to counter. Okay, you don't need to use up the paper on it. You don't even need to entertain it. And the reasons generally are that there's really no legal relief that the judge can give the person for some of the things they're accusing you of. But let's address why they're not accusing you, but some of the things that they're just kind of venting about you or complaining about you, right? Like, oh, you're a terrible parent because you let your child watch too much TV, right? Or you feed them different types of foods, and one parent thinks that the child should be vegan and you eat meat. So what a horrible person. Yes, I know, Peter, there's some states where they've used it against parents, like the father who didn't take his child to McDonald's. However, the reason those things get that way and get used in court is because they are allowing inflammatory testimony and inflammatory issues and complaints to become the case. So you really need to take control, and you need to reframe your case. And if they're saying things about you that are untrue, that really don't give the court any way to give relief for that, it's not violating a law, it's not harming your child, it's just a matter of differences, you need to reframe those things as, hold on here, I'm going to turn this on so I can get some light. Sorry. You need to reframe those things as this is First Amendment rights. These are just viewpoint differences, all right? They're not, they're parenting differences, but they're not to the magnitude that they're harmful to the child. Children have multiple teachers in school. Each teacher has a different set of rules. They have different beliefs. They teach the children different ways of doing things. It's not harmful to the child. So what I would really encourage all of you to do is talk with the attorney, make sure that they're on board with blending the way that they generally practice and the way that you would like them to protect your rights and reposition your case and reframe it. If they're not willing to do that, and you truly believe that it's important to have your rights protected, which by the way it is, because without rights, you guys, you can't even argue or object to what the court's doing. So if you believe that you have those rights, you need to make sure that the representation that you're getting is putting that into the way that you present your case. So part of this will help you focus or refocus on what's important and what is not. Now, that does not mean that you are not going to present certain facts in your case to make sure that you get enough on the record that says, hey, I've also satisfied, and I don't know why that light keeps going off. You want to make sure you say, hey, I've satisfied the statutes in a particular way as well, but just make sure you're not using the statutes to violate the other person's rights. You're just making sure that you've put on the record what's required by the court, and that you're objecting if they require certain things that are protected First Amendment association rights with your child, protected privacy, family decisions with your child. So I know this sounds different, and it is different. And the reason I'm bringing all of this up is because so many people get stuck in their emotions, and that's all they want to present to the court, and the court gets worn out, and then they just pick somebody, right? And so you may think, but Sherry, the court says I don't have any rights. What's the point? The point is, you guys, if you don't have rights, you couldn't object in the first place. You might as well just do what they tell you to do. Go ahead and spend your hundreds of thousands or several thousands of dollars. I know a parent just recently was over $600,000 that they spent. Go ahead and keep spending that and keep getting the same horrible results. Or you guys will start to insist that your case get reframed this way, and don't get lost in the drama of your case. That's why people come to people like us. We help you restructure, we help you re-strategize what you're doing, because this drama fighting is what's draining not just you, but draining the judge, draining everything out of everybody in the entire process. You want that to stop, then you've got to be brave enough to change this as well. The courts are accusing parents of bringing the drama to them and asking them to make a decision between the two parents. Then stop it. I understand the other parent is asking the court to make that decision. You take control. You ask your attorney to take control and tell the court that's not what you're there to address. So you got to put your emotions in check. You got to make sure that you're not falling into that trap and that you're not going in there to prove the truth that you're a good parent. Make sure that they're not presenting anything that can be used as a proper cause of action to restrict you from your child and get the court to think that you're harmful to the child or a danger or unfit. Anything other than that, reframe it. So I'm not saying don't address something. I'm saying don't address it back with an accusation back or blaming them back. Let me see what some of you guys are saying. There's a lot of you making comments here. Oh shoot, I gotta put my glasses on to do it. Excuse me for a second. You don't want to spout off too many facts, Peter says, because any of these can be used against you for the judge's objectives. That is excellent, Peter. Yeah, of course, you know this. You're an attorney. You spout off too many facts. Not only does that get used against you, but you may open the door. Darn light. You might open the door to something or an issue. Let's say your mental health. Let's say your medical records. Or let's say some past history into something that was originally private. If you open that door, it's open. The other side can get that stuff in. They can do discovery. They can get testimony out of you. So don't open the door. Let's see. Damon says, I find many courts are not moved by facts, civil procedure, substantive law, or evidence. Well, Damon, that's because these courts are of the belief that the parents are inviting them into their life. They are waiving their rights. They are asking them to choose between the two of them because they're in disagreement. You have to frame your case up right. You've got to make it clear what you're asking the court to do. And if you don't agree with that court being authorized by a specific statute, you've got to tell them why you're disagreeing with it, and you've got to give them some authorities to say, here's where I'm getting my analysis. And sure, maybe it's not, something that's generally used, but you've got to prove then that you believe there's been flawed analysis going on or that times have changed. So it's a lot like, let's take an example of back when, if you guys are familiar, Ron just recently mentioned in his podcast, Plessy versus Ferguson, right? Plessy versus Ferguson was a ruling that said blacks are second-class citizens, right? And that took 100 years before that case got overturned, and that was decided that was flawed logic, and that was in Board of Education. So it's not that things cannot change, it's that people have to believe that they have these rights and they have to actually demonstrate and use them. And that means you can't get caught up in your emotions, right? So someone's saying something about Plessy. Let me see. Okay, Peter, Plessy does not apply in a family court. Oh, I know, Peter. I'm not saying Plessy applies. I'm just using it as an example that laws do change, because some people say things like, well, that's not how the court does things, right? Well, the courts in family law are they change with the culture. I mean, just like Peter, remember just a few months back in Arizona, they said the court can't be a super parent. Well, if you look back in the early 80s, they allowed courts to be super parents. I mean, you were even shocked over the Arizona case. So I'm not using it as an example to be used in the court. I'm just using it as an example to show them that you can get precedents overturned, and it's a matter of demonstrating that there's been a cultural change, a cultural belief, and those types of things. So Trish, I appreciate it. She says, don't be emotional. I learned the hard way. Yeah, unfortunately, most of us did, because it is our children. It's a very emotional subject. And, but all is not lost. We've got lots more parents that unfortunately are going through it, but fortunately they can all learn from us. So let them learn from your mistakes. Let's see. So Peter says, family courts are emergency courts that offer emergency orders for the asking. The petitioner simply needs to make the correct statutory arguments, and the petitioner gets the relief. Okay, so Peter's stating from his legal background that he is saying that if somebody comes in and demonstrates that they've met all of the statutory requirements for something, they get it. And of course, that's the way they're going to operate. However, the part that I'm talking about, I'm not talking about emergencies tonight. I am talking about just your general divorce was filed, custody petitions were filed, and they're just going through the normal course of the process, and they get into their hearings, like their temporary hearings, and all of a sudden they start arguing for the judge to decide best interest, and they start giving testimony about which parent is better. That's the type of hearing that I'm talking about, Peter. I'm not talking about the emergency. The emergency ex partes are completely different bird here. Let me see what other questions we have. Oh gosh, phone's ringing again. Okay. So another comment is from, okay, someone asked you a question, Peter. Someone said if it's an administrator, they need your consent, right? So go ahead and message Peter on that, Marauder, because I don't know what you're asking me there. Peter says your rights are contained in your state's Family Court Act. Okay, I'll have to disagree with that. That's what the family court wants you to believe. That's what the states say, but that's not all where your rights come from. The courts actually not only apply their statutes, but they are also supposed to be interpreting or applying appellate court law, Supreme Court law or rulings, right? And they're supposed to be blending all of that. So your rights are not only what's in the Family Court Act, those are just the rights that they're listing out. If you notice in some orders, it'll say that those are not all of your rights. Okay, so I'll give you an example. I looked at someone's, I looked at it, sometimes I'll go in and I'll read orders or motions I can get offline, and I read this one where they never even said anything about the parents' rights regarding their child's estate, right? But yet the state had a statute that said that each parent has a right to the child's earnings, okay? And this is important because child support and also Social Security benefits. So both parents had the right to the child's earnings, and each parent has a right, according to federal statutes and in most states, to also manage the estate of their child, the estate that derives from them, their side of the family. However, this particular parenting plan and order did not have anything in it about those particular rights. Does that mean those parents no longer have those rights? No, it does not. It means that they still have them. They're just not specified in the order. So you don't always specify all of your rights. There's a penumbra of things that you need in order to actually exercise your rights, and they're not all listed out. The Constitution's the same way, right? We have a penumbra of rights. They don't always get listed out. Like we have the right to interstate travel. That's not directly in our Constitution. It's been interpreted by case law to say that we require that ability in order to exercise our other rights. So the same thing happens in family law. So you need to be sure that you understand what your rights are. You don't need to know every single one. You just need to understand that main things like First Amendment protects your intimate and expressive association with your child. So when the courts are coming in and applying best interest, what they are doing is they are making a viewpoint decision, or we call it viewpoint discrimination, based on their idea of what's best for your child. And what we say is your intimate expressive relationship with your child is protected by the First Amendment. So in order for the judge to justify applying that best interest, they need to make sure that they have applied the correct constitutional guarantees in order to come in and override your decision, no matter whether or not the two parents are in disagreement. And the way you can analyze that and figure out why that's actually a good analysis, and I know I'm not saying that right, I'm so tired right now. The reason we analyze it this way is because if you look at other rights, right? If you look at First Amendment rights in the First Amendment rights in the context of, let's say, just general speech, right? You're in public, you're talking, somebody comes up to you, they don't like what you're saying. Let's say you're not even cursing, they just don't like your view. So let's say they take you to court and they say, I don't like that person's view, I want you to tell them to shut up. They're not allowed to say those things, put a gag order on them. Well, the court has to show compelling state interest, and they've got to apply all of the constitutional guarantees for First Amendment that includes strict scrutiny before they can justify restricting you or putting a gag order. So generally, they'll come in and say, no, we cannot restrict this person. We don't have that jurisdiction or power to do so. That is not a proper cause of action. We cannot do anything about it. Sorry, you're offended. It's not illegal to offend you in that instance. Well, I apply that same logic to family law. And so many attorneys, judges, they just completely overlook this because they're like, well, parents are asking me to do this. Stop it. Don't ask them to do it. Learn your rights this way so that you can express it to the attorney, and the attorney's got to trust that you can handle this. Also, by the way, guys, it's not just, hey, I'm going to tell my attorney to do it and he's going to do it, and when I lose, I'm going to get pissed off at him. So Peter, attorneys like you, have them sign a contract. You've asked me to do this novel approach. You've asked me to defend your case based on these rights that you say you have. I'm telling you the statutes are saying the judge has broad and vague, overbroad discretion, which, by the way, Peter, if you ever do any cases like this, just put that all in writing, that they understand that that's what the challenge is, because it is a difficult challenge. It's well worth it. It does give them leverage, and it's the only power that we have as parents, but attorneys don't like it because that statute gets used so often and so much that it's just like steamrolling over you now. So yes, you've got to fight for it, just like slaves fought for freedom. So let's see. Peter says any state's Family Court Act is all the compelling interest the state needs to withstand strict scrutiny. Peter, you're killing me here. That's not how it works. That's not a compelling interest. That's putting too much all in one thing, but I'd have to explain compelling state interest to everyone before we could get into that. You guys, listen to Ron's podcast, by the way. He will be explaining those. I'm not going to have time to go into that here. But the Family Court Act that he's talking about, there are ways to challenge sections of it, and one of the ways is First Amendment. That's why I'm talking to you about that right now. So I'm telling you, when you get lost in your emotions and you can't figure out what it is to help you refocus, what you need to refocus, I'm asking you to go back to this video, come to our blog site, come to us and talk to us so we can refocus you and get you to use that energy, that emotional energy, on things that empower you, that give you leverage to challenge these abuses of power. Because if they're using Family Court Act or they're using statutes to justify these things, you're going to have to know how to challenge that. Because like Peter's showing you right here, they're going to just jump right on to, hey, we've been doing this for a long time. This is how we do it. We're going to keep doing it. So you've got to make your challenge formidable. Peter also says a judge can yank a kid for any safety reason, can find that a child requires yanking. All that is needed is an allegation. We know they do this. As you just saw recently with a judge in Texas, CPS just got one of the highest sanctions any CPS worker has ever gotten. And that's because, sorry about the light, guys. And that's because this judge decided not to do the status quo and just believe the CPS worker, but he decided to go ahead and charge him for the lies that he was telling. So it can happen. And if the other attorney on the other side wasn't presenting a case to get the judge to do that, he wouldn't have done it. So you've got to change up how you present. And you're welcome, guys. And let me see if you have any other questions. Now, Quinn, you say they have to follow the Constitution. Well, they've been violating it for a long time and then claiming that they're not violating the Constitution. But what we're saying is look at all sorts of different examples in history where anyone in power will test the waters, and they'll keep pushing their line and violate the Constitution for as long as they can. They'll do all sorts of things to try to hang on to that power so they can keep abusing their power, just like they did when they first gave blacks the right to vote. They made them get someone to sponsor them before they could vote, so they put burdens on it. Well, they're putting burdens on you as a parent right now, and that's why a lot of you are panicking. I mean, look, you've got Peter here saying things like, hey, they've got a statute that says they can do it. Hey, they can yank your kid for anything. Of course you're going to panic. Of course you're going to get emotional over it, right? And so that's how the Constitution gets lost. Don't lose it to your emotions. Use those emotions to empower you. Someone says, what can you do when your civil liberties are violated? You've got to step through this, Darlene, just like we're talking about. You can go over to our website, www.fixedfamilycourts.com. Go to our blog site. There's lots of free information. We have a membership that has information on there as well. We have a podcast we've been posting for free that's starting to explain different terms, like Ron just explained in his episode 2, intimate and the difference between intimate and expressive relationships. And so he's going to be doing lots more of those. He calls it UPLA, which is unauthorized prospective legal analysis. He uses that because, as you all might know, we're challenging UPL right now because we feel that they cause people to fear giving you information, and they don't allow people to help you who are not attorneys with meaningful information. And so you only get whatever the attorneys want to tell you. People are scared to give you any kind of information or help you because they will shut them down. So thanks, Darlene. I'm glad you have the book. If you need to find things more quickly, Darlene, we have all of our books in our membership site in digital format. You can actually search them digitally. So instead of going to the index in the back of the book now and trying to do it manually, you can now have a search feature in them. So if you need something quickly, you can find it. Damon, you say strict scrutiny should be applied for the state to violate any fundamental rights. That is absolutely correct. But what they try to do is they say that because the two parents brought it to them, and it's between two parents, and that their rights are in conflict, that they don't have to use the high standards. We argue with that. We do not agree with that. Of course, the attorneys are going along with it because the judge has such broad discretion right now, and it hasn't been challenged often enough to where now, if they challenge it, the next cases they have in that judge's courtroom, the judge can punish them. So it's very hard to find attorneys who are going to argue that for you, which is why so many parents are needing to go pro se at this point. So while there are lots of legal technical things that can you can run into trouble when you're trying to do these on your own, so many parents have found themselves in positions where they don't have any choice. That's why we're giving you guys this information. That's why we're defining things for you. That's why we're providing you with analysis that nobody else has been willing to provide, because parents have been lied to, cheated, stolen from, raped, and bankrupted. And we're tired of it, and we're not going to stand for this anymore. So let's see. See if anyone else has any more questions. Thanks, Darlene. I love how she says, yes, the attorneys womp out. I love that term. I think I'm going to use that. So, okay, Steven says Custody Warriors has crap loads of files and info for free. Okay, awesome. So you guys will want to check that out as well. So anyone you know that has other free information for parents, just go ahead, post comments here. Let everyone know. They all need to be able to find information. But if you want to get an organized, structured way to approach your situation, and you want to learn how we apply our analysis so that you can start applying it so that it keeps you on track, then you'll want to go to our site and come to us with that. We will help you make sense of all of the information overload. You want to be super cautious about what you do get from other places, especially if you're not understanding the terms, if you're not understanding the consequences, and if you're not understanding what happens when certain things are used, and you want examples of what's happened to others so you can prepare and make choices, more informed choices, then come to us so that you can have that information, and we're happy to analyze things as well. So if you do find things in other sites and you're not sure, because be careful about blending things with certain approaches, right? You don't want to blend something in that's going to contradict or counter what you're trying to do or ask for. A lot of places don't understand that. So even free things, so if they're reposting free motions and stuff that they're getting from the states, those motions were created by attorneys, so they're not going to have the rights information in there for you, and sometimes some of the wording will contradict and will actually ask the judge to use broad discretion. So just be really cautious about that. Let's see. Cases are sanitized and published in rare instances, Peter says. You see no settlements and no dismissals. Not sure what that is, Peter, or if you're talking to me. I think you're just trying to throw it. No, I'm just kidding. So, Peter, I don't know what that is. I don't have a lot more time. Sorry. Appreciate it, Stephen. Appreciate it, Trish. That's about all I have to say tonight. So you guys get in touch with me. If you need some more information, listen to Ron's podcast. Like I said, we're posting on Fixed Family Court's Facebook page and on our website blog. And if you all haven't heard, I do a show with 3 other brilliant ladies who are on what's called the 4 at 4. We were airing it on Thursdays. We're now airing it on Mondays on Facebook Live. It's on a page called The 4 at 4. We'd love it if you go on that page and like it, so you'll be notified when we're on live. All of us are published authors, and we all talk about lots of different issues. It's not just the family court issues, but we do relate them back to family court whenever we can, so that all of our followers can understand how those might be affecting them, and how the public can understand how family law is affecting everybody, how it's impacting everything: our productivity, our children's health, our adult health. It's impacting our economy. It's impacting our volunteerism in society. It's impacting everything that we do. And this family court process cannot survive this. It just cannot. So it's either going to change with the times, or you're going to see happen what just happened in Harris County, down in Houston, where every single judge was fired. Every single one. And by fired, I mean the voters just voted them out. Every single family court judge has changed, and it went from all Republican to all Democrat judges. So judges, you want to keep your jobs, you're going to have to change. That's all I have to say. Thank you, everyone. Hope you have a good night. Talk to you next Tuesday, and hopefully you'll join us on Monday. And also, the other ladies do lives at 4 on their personal pages as well, so make sure you jump on their pages too. If you want to know who they are, jump on the 4 at 4 page. Bye, guys.